Hello everyone and welcome to this fire safety overview. By way of introduction, my name is Hannah Eales. I am a partner at Kingsley Napley law firm. I'm a barrister by trade and I specialise in fire safety. My background is in criminal and regulatory law. I've been dealing with fire safety cases for around 15 years. My background in terms of fire safety is that I've acted for National Fire and Rescue Services in bringing prosecutions through the criminal courts for breaches under the fire safety order. And that's from the Magistrates Court through the Crown Court up to the Court of Appeal. I've also defended those facing enforcement action by the Fire and Rescue Service, including company directors, property owners, management companies, and fire safety professionals themselves. The main bulk of my work is advisory, so advising on compliance under the existing regime, but most recently advising on the legislative changes that have happened following the tragic Grenfell Tower fire, for which I'm also acting in the inquiry. So that involves the Fire Safety Act, the Fire Safety Regulations, and of course the Building Safety Act. The key is getting it right from the beginning so that the enforcement end of things doesn't happen, but then we do also work with organisations and individuals from cradle to grave to ensure compliance, and we're there should things go wrong and the Fire and Rescue Service bring enforcement action. So today we're going to look at some of the recent legislative changes that have occurred in the world of fire safety, particularly at the Fire Safety England regulations, which came into force of January of this year, and how those regulations affect those who have health and safety responsibilities, including looking at the role of the responsible person. We'll look at the Fire Safety Act, the Fire Safety England regulations, Section 156 of the Building Safety Act, which came into force earlier this month, and then we'll come on to look at enforcement. One of the key concerns of Dame Hackett, highlighted in her review following the Grenfell Tower fire, was the lack of clarity around responsibility and roles in terms of fire and building safety. Dame Hackett was right. Identifying who is the responsible person can be complex and time-consuming, and yet it is so important to understand who is the responsible person so that that person or entity can understand what their responsibilities are and ensure they comply with them. With a wave of new legislation and regulation coming in around building and fire safety, I thought it would be helpful to look again at the role of the responsible person specifically and how this fits into the new regime that's coming through. So let's go back to basics and start with who is the responsible person under the legislation. The Regulatory Reform Fire Safety Order 2005, FSO, RRO, Fire Safety Order, it has many names, that's been in effect since April of 2006, and it sets out the definition of the responsible person under Article 3. And that is defined as in relation to a workplace, the employer, if the workplace is to any extent under their control. In relation to any other premises, the responsible person is the person who has control of the premises in connection with the carrying on of a trade, business, or other undertaking. Now, in those circumstances, it doesn't matter if the person who has control occupies the building or not, and it doesn't matter if the person makes a profit from the said trade, business, or undertaking. If the person in control of the premises doesn't have control in connection with the carrying on of that trade, business, or other undertaking, then the responsible person is deemed to be the owner. And the responsible person doesn't need to be a person. It can be an entity or organisation. And quite often in practice, enforcement action will be taken against an organisation or company, but then also against the director of that company as an individual. So, as I say, the responsible person can be an individual or an organisation, and there can be more than one responsible person. The order states that any duty imposed by the order on the responsible person in respect of certain articles under the order shall also be imposed on every person other than the responsible person who has to any extent control of those premises, so far as the requirements relate to matters within their control. So, for example, I've had cases where the responsible person has been a fire safety professional, such as a fire risk assessor, whose fire risk assessment had been deemed in breach of Article 9 in that it wasn't suitable and sufficient. In those circumstances, they were deemed liable under Article 5.3. So the order is far-reaching and encompassing in its effect. By way of another example, I had a case where the premises was student accommodation and the owner the managing agents and the construction company were all deemed responsible persons, and all were prosecuted. The facts of the case were that the student accommodation was open to students at the start of term, while parts of the building were still under construction. The father dropped his daughter off at the building and had some serious concerns over the state of the building, so called the local fire and rescue service, and he was so concerned he wouldn't let his daughter stay. Inspectors came and issued a prohibition notice, meaning the students all had to leave. The fire safety defects included only having one fire escape, which was found to be unsafe due to building materials being left on the stairway, a lack of an appropriate fire alarm, inappropriate storage of flammable items, and no signage for escape routes. So the construction company hired to design and build the flats were prosecuted as a responsible person, and the owner and managing agents were also charged. And I'll come on to talk about what happened to them a little bit later, but it's illustrative of the fact that there can be more than one responsible person. In our case, the Fire and Rescue Service had charged both the individual and the company, and we persuaded the Fire and Rescue Service through representations to drop the case against him as an individual, instead focusing on the company of which he was the director. A brief word on the accountable person and the responsible person. So I'm sure you've all heard about the new duty holder regime brought about by the Building Safety Act. Many people assumed that when the new legislation in the form of the Building Safety Act came in and its duty holder accountable person regime, the responsible person role would go, but it hasn't, and it sits alongside the new roles created under the legislation. So whoever is the responsible person in a given organisation still has those responsibilities and is still liable. The responsible person and the accountable person can be the same person, and likely will be when you look at the definition of the two. The accountable person is the person or organisation who owns or has a legal obligation to repair any common parts in the building, including the structure and exterior. So this will clearly cross over with the definition of the responsible person, given the definition that we looked at moments ago. However, remember that the Building Safety Act and the accountable person role only applies to what we call higher risk buildings. So that is buildings over 18 metres in height or 7 stories, and containing 2 or more residential units. Whereas the fire safety order and the responsible person regime doesn't have that height restriction. Turning then to the Fire Safety Act 2021. This act came in May of last year. Before the act, there was some ambiguity as to whether external walls and doors came within the scope of the fire safety order, and therefore the responsibility of the responsible person. My view is that the external wall system was previously clearly not in scope, and most fire and rescue services, I think, hold that view. But the government has said it was ambiguous and that they, through the Fire Safety Act, clarified matters. Either way, the Act clarifies that in buildings containing 2 or more sets of domestic premises, and this is irrespective of the height of the building, excuse me, the FSA applies to the structure, the external walls, so that's doors, windows, balconies, and anything attached, so that would include cladding, the common parts, and flat entrance doors. In terms of the external walls, the order specifies that that includes your doors or your windows in those walls, and as I say, anything attached to the exterior of those walls, and that would include balconies and cladding, as I've stated. In terms of the doors between the domestic and common parts, that includes your front doors to individual flats, and the responsible person is responsible for ensuring the fire safety of those doors. So under the order, the responsible person's remit has now expanded, and this has caused some to question how a responsible person is expected to go about ensuring the fire safety of the external walls. The Home Office guidance on the Fire Safety Act suggests that the responsible person or a competent fire risk assessor acting on their behalf should first undertake a visual inspection of the external walls They say that in many cases it will be manifestly obvious through a visual inspection that the risk to life from external fire spread is not such as to warrant a PAS 9980 assessment. What is a PAS 9980 assessment? Well, in January 2022, the BSI published PAS 9980, a new code of practice for appraising the fire risk of external wall construction and cladding on existing blocks of flats. The Home Office have said that the sufficiency of a simple visual inspection is particularly true in buildings with brick or masonry external walls, or which do not present any significant risk of fire spread. In these cases, the Home Office state that the fire risk assessor will normally address compliance of external wall construction with the fire safety order as part of the routine fire risk assessment process. A more detailed fire risk appraisal under PAS 9980 may be required if there is a known or suspected risk from the form of construction used for the external wall, such as the presence of combustible materials used for cladding or external wall insulation. One of the other things the Act implemented is the idea of risk-based guidance. The government have produced guidance in the form of the prioritisation tool, and they may add other guidance in due course. As with all guidance, use of the risk-based guidance and the prioritisation tool is entirely voluntary. However, Section 3 of the Act modifies the fire safety order, making specific reference to the fact that proof of compliance with any applicable risk-based guidance by the responsible person may be relied upon to establish that legal duties were met. It may be referred to and relied upon, therefore, in relation to any legal proceedings concerning an alleged contravention of the duties under the fire safety order. Following the guidance does not introduce a statutory defence, but it does provide a useful benchmark. And the Act similarly provides that proof of a failure to comply with any risk-based guidance may be relied upon by the prosecution as tending to establish that there was a contravention of the order. So, not mandatory, but giving the prosecution ammunition if you don't comply with the guidance. In terms of the prioritisation tool, that takes responsible persons through a series of specific questions, which are each carefully scored to assist them to determine the priority of their buildings for the purpose of reviewing their fire risk assessments. The tool does this by allocating each building to one of 5 priority tiers. The tool is part of the package of risk-based guidance that, when complied with, will help a responsible person show that they have undertaken appropriate steps towards establishing compliance with the fire safety order. These steps will then need to be followed up in accordance with the priority rating given to the building. The prioritisation tool doesn't constitute a fire risk assessment. Rather, it supports the responsible person to identify what steps they need to take and how they could prioritise their buildings to update their fire risk assessment. So it asks a number of weighted questions, and then you get a priority rating in one of those 5 tiers. The government have recognised that the capacity of the responsible person to undertake a fire risk assessment of the premises, in particular the external wall system, may be limited. And they've also stated that they recognise that even the capacity of competent professionals commissioned by the responsible person may be limited. The Fire Risk Assessment Competency Council has published a set of criteria against which the competency of those undertaking fire risk assessments can be judged. And the list is on the NFCC website and includes things such as an understanding of relevant best fire safety practices in premises of the type in question, an awareness of the limitations of the fire risk assessor's own experience and knowledge. And then for more complex premises, fire safety professionals are expected to meet more detailed criteria, such as anticipating the way people will generally behave in fire situations, or an awareness of how different structural designs of buildings behave in a fire. So one can ask for evidence of compliance with the competency requirements and check that an individual has experience for the type of premises they're dealing with. References could be requested, for example. Appointing a fire risk assessor impacts on the question of responsibility. Again, to give a case example, I represented a fire risk assessor, as I mentioned earlier, who had been deemed the responsible person under Article 5.3. He was the senior fire risk assessor at a company of risk assessors and was employed to look at a premises and provide a risk assessment. He came to us when the Fire and Rescue Service had reason to evacuate the premises in question, and in due course looked at the fire risk assessment and felt it wasn't suitable and sufficient. So they brought proceedings against the fire risk assessor as the responsible person in that case. We got the case dropped before any prosecution in making representations in terms of the actual sufficiency of the fire risk assessment. But again, it just shows that everyone can be caught under the fire safety order. Looking now then to the Fire Safety England Regulations 2022, they came into force in January of this year. They were introduced under the Fire Safety Order, and they're intended to implement the majority of the recommendations made to government in the Phase 1 report of the Grenfell Tower inquiry. They place new responsibilities on the responsible person, and there's different responsibilities placed on the responsible person depending on the height of the building. So high-rise residential buildings, so 18 metres or 7 stories or above, the responsible person must provide the local fire and rescue service with up-to-date electronic building floor plans and provide a hard copy of the plans, along with a single-page building plan in a secure information box on site. The responsible person must provide the local fire and rescue service with information about the design and materials of the external wall system, and must now inform the fire and rescue service of any material changes to the external walls. That includes providing information in relation to the level of risk that the design and materials of the external wall system give rise to, and any mitigating steps taken. The external wall system includes, as I've said, windows, balconies, cladding, insulation, and fixings. The responsible person must undertake monthly checks on the operation of firefighting and evacuation lifts, as well as functionality checks on other key pieces of firefighting equipment. And any defects should be reported to the Fire and Rescue Service as soon as possible after detection if it cannot be fixed within 24 hours. The checks should be recorded and made available to residents. The responsible person must install and maintain a secure information box in the building containing the name and contact details of the responsible person and hard copies of the building floor plans. And finally, in those high-rise residential buildings, install signage visible in low light or smoke, which identify flattened floor numbers in the stairwells of relevant buildings. For your buildings 11 metres and above, the responsible person must undertake annual checks of flat entrance doors and quarterly checks of all fire doors in the common parts. And for your multi-occupied residential buildings with 2 or more domestic premises, for clarity, that description doesn't apply to 2 flats in a converted house or a maisonette, where there's no common parts through which individuals would evacuate. Instead, it's aimed rather at blocks of self-contained flats. So in relation to those premises, the responsible person must now provide fire safety instructions to their residents, including how to report a fire and what to do if a fire has occurred, and provide residents with information relating to the importance of fire doors in fire safety. Fire and rescue services have said on their websites how they would prefer to receive the relevant information, and the government have also produced templates in collaboration with the fire and rescue services. Now, earlier this month, on the 1st of October, Section 156 of the Building Safety Act came into force, and again, this means further responsibilities for the responsible person. In particular, previously, responsible persons only needed to record the significant findings of the fire risk assessment. However, responsible persons must now keep a record of a full and completed fire risk assessment, including all the findings, as well as the fire safety arrangements for their premises. They must also record the identity of the individual or organisation engaged by them to undertake or review the fire risk assessment, and should hold as much information as possible about the premises fire safety. Responsible persons must identify whether there are other responsible persons in their premises, and if there are, then they must share with all other responsible persons their name and a UK-based address, which can receive notices or other documentation. The responsible persons are also required to inform each other in writing of the extent of their responsibilities under the order and must make a record of this information. If a responsible person has a new responsible person taking over their part of the premises, then they should let the other responsible persons know to allow for the information to be shared with them. If a responsible person is in a higher risk residential building, then they must now take reasonable steps to identify the accountable person or persons within the premises and cooperate with them to enable them to perform any duties they're required to perform under the Building Safety Act. So that would include, for example, sharing the fire risk assessment. Finally, the section of the Act requires responsible persons to share any relevant fire safety information with incoming responsible persons to, and I quote, provide a continual record of fire safety information throughout a building's lifetime. There is guidance that goes alongside the Act, and that sets out the following fire safety information which the existing responsible person must provide to a new responsible person. So the fire risk assessment and review records, the identity of any person who assisted with the fire risk assessment or review, the name and UK address of any responsible person or person acting on behalf of the responsible person who will accept notices or other documentation, the identity of the accountable person where known, any information given under Regulation 38 of the Building Regulations 2010, such as the information provided when a building is built or extended. In respect to buildings which contain 2 or more sets of domestic premises, the government have said that the new requirements aim to help residents feel more informed and involved, and as such requires responsible persons of those buildings to provide the following information to residents. Any risk identified in the fire risk assessment in respect of any risk to residents, the fire safety measures provided for the safety of any or all occupants, so that's your means of escape, the measures taken to restrict the spread of fire and what people should do in the event of fire, the name and UK address of the responsible person, the identity of any person appointed to assist with making or reviewing the fire risk assessment, the identity of any competent person nominated by the responsible person to implement firefighting measures, and any risks to relevant persons throughout the building that have been identified by other responsible persons in the building. So the remit of the responsible person has grown with this new legislation. Coming on then finally to enforcement. Well, in my experience, fire and rescue services are historically slow to prosecute. They would rather work with an individual. In my experience, they will be fair and consider the seriousness of any breach, any previous history of such breaches, the cooperation and action taken by the person or organisation concerned, and ultimately the risk of death or serious injury to relevant persons. There are a number of measures the Fire and Rescue Service can take, including giving you advice, formally writing to you, or issuing a notice. Now, alterations notices are issued where the enforcing authority is of the opinion that the premises constitutes a serious risk to relevant persons, whether due to the features of the premises, their use, any hazard present, or any other circumstances, or the premises may constitute such a risk if a change is made to them or the use to which they are put. If in receipt of an alterations notice, the responsible person must, before making any changes, notify the enforcing authority of the proposed changes. Enforcement notices, now they allow a period of time for certain things to be remedied or actioned. An enforcement notice must state that the enforcing authority is of the opinion that the responsible person or any other person mentioned in Article 5.3 has failed to comply with any provision of the order or any regulations made under it, and why. It must specify the provisions which have not been complied with and must require the responsible person to take steps to remedy that failure within a period of time not less than 28 days. Finally, a prohibition notice. If the enforcing authority is of the opinion that use of premises involves or will involve a risk to relevant persons so serious that use of the premises ought to be prohibited or restricted, the authority may serve on the responsible person or any other person under Article 5.3 a prohibition notice. And that notice will explain why the Fire and Rescue Service is of the opinion I've just outlined and direct that the use of the premises is restricted or prohibited as described in the notice until specified matters have been remedied. So while the fire and rescue services are, in my experience, slow to prosecute, it's fair to say that there has been a noticeable increase in the issuing of enforcement notices since the Grenfell Tower fire and subsequent inquiry. In terms of who can issue these notices, they're usually issued by officers from the local fire and rescue authority if it's deemed that the standard of fire safety is unacceptable. But other agencies can also bring enforcement action in differing circumstances, such as the HSE or the local authority. These notices are sometimes issued after an incident or as a result of a routine inspection by the Fire and Rescue Service, and often in cases I've been involved in, they're issued as a result of an inspection when an individual has reported concerns. The Building Safety Act introduced the Building Safety Regulator, which I'm sure you've all heard of, and that will fall under the umbrella of the HSE. The BSR, as it will be known, will be an independent regulator with its own powers and programme of work, including giving expert advice to local regulators, landlords and building owners, as well as those working in the construction and built environment industry, and finally for residents. In terms of regulation, the government state that the BSR will implement a new, more stringent regulatory regime for high-rise buildings in England, being the Building Control Authority in England for building work on high-rise buildings. It will oversee and enforce the new regime in occupation of high-rise buildings. It will oversee the performance of other building control bodies and will advise upon existing and emerging building standards and safety risks. Finally, it will promote competence among industry professionals and regulators to raise standards in the design, construction and management of buildings. The Building Safety Regulator has real teeth, similar to the HSE. Once it is fully up and running next year, it will likely start bringing enforcement action under the Building Safety Act. So again, the advice would be for everyone to get their house in order now to avoid what could be significant consequences for non-compliance. In terms of penalties under the Building Safety Act, there are various offences such as contravening compliance notices, failure to register higher risk buildings, or applying for a building assessment certificate. Penalties are up to 2 years in prison or an unlimited fine. Similarly, under the fire safety order, the penalties for a breach are an unlimited fine or 2 years in prison for the responsible person. And I have seen custodial sentences imposed on individuals for breaches of the fire safety order. I acted in a case for a fire and rescue service where the defendant tried to appeal a custodial sentence that had been imposed for those breaches. The Court of Appeal rejected the appellant's argument over the suitability of imposing a custodial sentence, stating that the lower court's decision that the offences past the custody threshold was appropriate given the risk of death and serious injury involved. When imposing a sentence, a court will consider the Sentencing Council's health and safety guidelines, looking at two factors, culpability and harm. The level of culpability will vary depending on the circumstances of the particular case. However, in fire safety cases, the harm category is always going to be the highest, given that for an offence to be committed, a failure has to place relevant persons at risk of death or serious injury in case of fire. Again, a reminder that the responsibilities that go with fire safety are serious. In imposing a financial penalty, the court will consider turnover figures and the size of the company and would expect to see annual accounts. Some further examples, and looking back to the student accommodation case I mentioned at the outset. Now, there, the construction company in that case was fined $450,000, the owner company $160,000, and the management company $60,000. The director of the owner company had originally been prosecuted, as I mentioned. However, the Fire and Rescue Service dropped the case against him as an individual, meaning a custodial sentence was out of the question, the company instead having to pay the fine. A further example is the Bupa case from January of 2022. That was an incredibly sad case where the London Fire Brigade brought the prosecution following a fire in March 2016 at a residential care home in southeast London in which a 69-year-old man in a wheelchair sadly died in a fire while smoking unsupervised in a shelter in the garden of the home. The victim had been prescribed a paraffin-based emollient cream. Bupa policy required emollient cream users to have further precautions for smoking, such as a smoking apron or to be supervised, neither of which were done. Bupa accepted in particular that it had failed to ensure staff understood the risks from the use of emollient creams. had failed to warn residents using paraffin-based products not to smoke or required precautions to be taken, such as the use of a smock or apron, had failed to instruct staff not to leave a resident using paraffin-based products smoking unsupervised, and had failed to carry out an individual smoking risk assessment of the resident as normal with the control measures in place. Bupa were fined a total of £1.4 million in fines and costs. All this said, in the main, the Fire and Rescue Service will work with responsible persons to try and ensure compliance. If there is a failure to comply, then there is a risk of an enforcement notice or prohibition notice being issued. If those notices are ignored, then the Fire and Rescue Service may consider prosecution. Of course, if the breaches are so bad, they may proceed to prosecution at an early stage. So compliance with the fire safety order and new regulations is key. Understand your responsibilities now and take action if you don't. Ensure that you understand what is happening in terms of legislative and regulatory reform and how this affects you and the particular part you play in the built environment industry. And if in any doubt, seek advice. I've been asked whether there will be increased enforcement action taken due to the new regulations. I think it's likely, just purely due to the fact that there are now a lot more things the responsible person has to do, and therefore there is a greater risk of them getting it wrong. But we will see. Well, that ends this session. Thank you very much for listening.
So thank you, Hannah, for delivering that presentation on the changing legislative landscape of fire safety. Based on your experience, what legal advice or insights could you offer stakeholders, for example, property developers, housing associations, local councils, etc., that are navigating this changing legislative landscape?
Thanks, Rebecca. Yeah, well, I think the key is understand the changes, read around the subject, and if you don't understand it, seek advice. The second key piece of advice I would give is that compliance is key. Get your house in order as soon as possible. Some of the enforcement action, particularly by the building safety regulator, won't really come into effect until next year. But if you comply now, A, you're less likely to get things wrong, so that enforcement action takes place, but B, you're giving yourself that chance to get up to speed before any enforcement action could take place by the regulator next year. And of course, with the fire safety order, that's in place already, and the responsible person, it's serious business, and I'm not sure everybody realises quite how serious it is, the responsibility of the responsible person. So understand what you need to do and ensure that you're doing it. And if you don't know what you need to do, then get that advice.
Definitely. And there's been a lot of changes, obviously, as we've established over recent years to building safety regulations. And there's been some controversies in terms of more on the competency side from the fire industry. But you mentioned in your presentation, you spoke about the Section 156, the Building Safety Act, which is obviously the newest of these reforms. Are there any potential challenges or controversies you see arising from this section change?
Well, I think, as I mentioned in my presentation, Section 156 has placed even more responsibilities on the responsible person. So, yes, I think there's going to be challenges for those individuals or entities that are the responsible person in terms of ensuring they know what they need to do and that they are doing it. And as I mentioned, I think that will potentially necessitate an increase in enforcement action, because there's more chance of things to go wrong, because there's a greater level of responsibility there.
And if a responsible person or a potential responsible person is finding it a little bit difficult to get up to speed, you're saying obviously to reach out for guidance, but who can they reach out to?
Well, there's obviously guidance out there that's been issued by the government. There's a huge amount of guidance simply if you Google new fire safety responsibilities. I have blogged widely on the subject, so I'm sure if you Googled, there would be a few of my blogs that would come up, which clearly set out the new responsibilities. But ultimately, fire safety lawyers like myself or others would be able to assist in those circumstances. And I dare say, if you got in touch with your local fire and rescue service and said, can I have a bit of assistance, please? I'm the responsible person. What do I need to do? They may welcome the fact that that individual is showing responsibility and trying to take action.
Definitely, because there's no harm in not fully understanding these changes, and you shouldn't let something like an ego, for example, get in the way of anything like that. And actually, like you said, showing that interest, seeking that advice, and seeking that guidance is something that's paramount to, it was demonstrable to their responsibility. So urge all kind of companies, building owners, responsible people to do that.
Indeed, at the end of the day, we're dealing with life safety.
Exactly.
So yes, there's serious consequences outlined from enforcement action in terms of the sentences that go along with that, and fines and custodial sentences. But ultimately, on a more human, basic level, we are dealing with life safety. That we've got to get it right.
Exactly. And I think we're seeing, obviously, with the adoption as well of new technologies, even things like vaping or electric scooters, all things like that are coming and being brought back into buildings, into residential in particular, that there are more fires coming in that structural side of things. So that perspective of, I only have a little small building, it's not gonna impact me, it's never gonna happen to me. And that kind of negligence is very important to address that, and I think we're doing that. So hopefully it can change and it will be a more positive future. And just lastly on the subject, what areas of building safety do you believe still need further attention or reform?
Competency. There's parts of Section 156 that haven't actually been brought into force on the 1st of October, along with the other changes. And competency, we all know it's a huge area of concern for all those working in the fire safety industry. I think I could do an entire other session on the question of competency, so I won't delve into it now. But I think that's clearly where focus needs to be.
In our previous event back in April, competency was one of our biggest themes. And we heard obviously from a whole multitude of speakers all talking about it, whether they're fire engineers trying to demonstrate their competency, or building surveyors, or so on and so forth, or association leads. So I think that is something, competency culture, and how do you demonstrate your competency, especially, for example, I think the majority of difficulty that we're seeing a lot as well is for example, a fire engineer or a third party who has been delivering fire safety, protocols for years, for decades even, and have all the knowledge. They don't have the certification to go along with that knowledge, or they might not have the funding to prove that they have the knowledge. So all these different aspects all coming in, and it's not just a lack of competency that we're dealing with here. It's a much wider challenge. But yeah, like you said, obviously we don't have time to go fully into that right now. Well, thank you, Hannah. I really appreciate your insights and your incredibly informative presentation. If anybody has any further questions, please reach out to Hannah directly on the platform, and you can find out more. Thank you.